Folks, I'm shooting this video because of the various Sunday morning talk shows that I saw yesterday, and I probably will shoot a few individual videos on that, but I felt that this video was more important to shoot first because it basically just shows how racist the United States of America has been throughout the years. And I'm not just talking about people being racist, I'm talking about the government being racist. As most of you are already aware, in the Constitution, black people were not considered fully human. We were only considered 3/5 of a human being, and that was only so that the southern states could obtain more political power than they would otherwise be entitled to, while still denying black people their autonomy, their freedom, their rights as human beings. So from the very beginning, black people have been put behind the 8 ball because of slavery and because of white supremacy. Now, what some of you may not know, but possibly quite a few of you do know, is that the federal government codified slavery in various ways. One of the ways that slavery was codified was the Missouri Compromise. The pro-slavery states and the anti-slavery states got together and passed the Missouri Compromise in 1820. It prohibited the practice of slavery in the western states, and it gave a geographic line as to what was considered north, south, east, and west. And for the purposes of this discussion, the line that demarked the north from the south was 36 degrees 30 minutes north. While it had the unfortunate effect of declaring Missouri a non-slavery state. So they created the Missouri Compromise, codifying that particular line, but it allowed the state of Missouri to be a slavery state. What you probably don't know is that in 1854, the Missouri Compromise was effectively repealed by Congress, and it opened up the Kansas Territory and the Nebraska territories to slavery. Again, that was known as the Kansas-Nebraska Act. So instead of slavery being outlawed in the brand new territories, slavery was specifically allowed in the Kansas-Nebraska territories, which effectively negated the Missouri Compromise's feature that slavery was not to be allowed north of a certain line and in the West. Now, just so that we can be clear, although the Kansas-Nebraska Act negated the Missouri Compromise, the Supreme Court turned around and added fuel to the fire, i.e. they threw their weight behind slavery in the Dred Scott versus Sanford ruling. Now, I'm not going to go into that particular decision. That's up to you to do your own research on it. Let's fast forward to recent times. As you can see, the title that I have up here is Davis-Bacon, Jim Crow's Last Stand. A lot of people don't know about the Davis-Bacon Act. So I'm going to try to give you some information on it. We're always being told, and by us I mean black people, that we need to pull ourselves up by our bootstraps, that we're lazy, etc., etc., etc. Well, when the federal government creates laws that specifically target us, specifically try to hold us down, those statements ring hollow. Now, the Davis-Bacon Act, which was passed in 1931, requires private contractors to pay prevailing wages to employees on all construction projects receiving more than $2,000 in federal funding. The Secretary of Labor is charged with conducting surveys of a region's wages and setting rates for up to 100 various classifications of workers. Most often, the prevailing wage corresponds to the union wage, especially in urban areas where union membership tends to be higher. The Davis-Bacon Act covers approximately 20% of all construction projects in the United States and affects more than 25% of all construction workers in the nation at any given time. Unions, and I'm not even going to say up till recently, but I will say through the 60s, 70s, and 80s, have a history of discriminating against black people. Now, I can tell you for a fact that if you were black and you were trying to get into any type of construction union, electrician union, pretty much any union other than possibly a teachers union, that you had to be sponsored by someone. Now, the only way that you could get in was to be sponsored by a person obviously already in the union, and the people that were in the unions were white people. So in order for a black person to get into a union, he had to be sponsored by a white person. Well, for the most part, that wasn't happening. And if you couldn't get into a union, you were determined to be an unskilled worker. What the Davis-Bacon Act did was it required that people working on any type of a government contract, construction contract for roads, buildings, highways, etc., had to hire people at the prevailing wage. But if you were an unskilled worker, you obviously were not going to be hired for the prevailing wage of a skilled worker doing the same job. This act obviously was passed in order to prevent non-unionized black and immigrant laborers from competing with unionized white workers. The discriminatory effects continued as even today minorities tend to be vastly underrepresented in highly unionized skilled trades and overrepresented in the pool of unskilled workers. Davis-Bacon restricts the economic opportunities of low-income individuals in a number of ways. If you were of the means to create your own contracting firm, you could not work on any type of a government project where the government was contributing, and it was $5,000 to the project, but that wasn't enough. They lowered it down to $2,000 in a project. Minority contracting firms were often small and non-unionized and couldn't afford to pay the prevailing wage, i.e. union wages. The Act also required contractors to pay unskilled laborers the prevailing wage for any job that they perform, essentially forcing contractors to hire skilled tradesmen, selecting workers from a pool dominated by whites. The Davis-Bacon Act constitutes a formidable barrier to entry into the construction industry for any unskilled or low-skilled worker. This is especially harmful to minorities because work in the construction industry pays extraordinarily well compared to that of other entry-level positions and would otherwise provide opportunities for low-income people to enter the economic mainstream because they were going to make more money. The Davis-Bacon Act was challenged in 1993 by the Institute for Justice, which filed a lawsuit claiming Davis-Bacon constitutionally was part of a discrimination program backed by the government. It claimed that this particular act was a major impediment to the progress of black people in order to get ahead. Now, you might think that the Davis-Bacon Act was something that was formulated by some person in the South who was trying to keep black people down. But that couldn't be further from the truth. The person who instituted or submitted this legislation for approval, his name was Robert Bacon. He was out of Long Island, New York, which everybody would think that New York is so progressive and forward-looking and not a lot of racism up there. That couldn't have been further from the truth. Mr. Bacon was a racist who was concerned about immigration and how it would upset the nation's racial status quo. He started in 1927 by introducing a bill to require contractors and subcontractors engaged on public works of the United States to comply with state laws relating to hours of labor and wages of employees on state public works. That action was a response to the building of a Veterans Bureau hospital in Bacon's district by a person in Alabama, or an Alabama contractor, who employed only black laborers. Mr. Bacon obviously saw that as a threat to employment of whites in his area, so that's why he put forth that legislation. Now, he was opposed by Representative William Upshaw, who knew that the racial implications of Bacon's proposal stated that you will not think that a Southern man is more than human if he smiles over the fact of your reaction to the real problem you are confronted with in any community with a superabundance or large aggregation of Negro labor, he wrote. Over the next 4 years, Bacon submitted 13 more bills to regulate labor on federal public works contracts. Finally, the bill submitted by Bacon and Senator James Davis was passed in 1931 at the height of the Depression with the support of the American Federation of Labor. The act required that contractors working on federally funded projects over $5,000 pay their employees the prevailing wage. The law was amended in 1935, reducing the minimum to $2,000 and delegating the power of determining the prevailing wage to the Department of Labor. The department's regulations governing the determination of wages remained basically unchanged for 5 decades and equated the prevailing wage with the union wage in any area that was at least 30% unionized. In practice, the prevailing wage was almost universally determined to be the same as, the prevailing wage was almost universally determined to be the same as the union wage. The debate over Bacon's bills betrayed the racial animus that motivated passage of the law. Representative John Cochran stated, "I have received numerous complaints in recent months about Southern contractors employing low-paid colored mechanics getting work and bringing the employees from the South." Representative Clayton Allgood similarly complained that contractors have cheap colored labor and he transports and puts them in cabins, and it is a labor that is sort of in competition with white labor throughout the country. Other derogatory comments were made about the use of cheap labor, cheap imported labor, transient labor, and unattached migratory workmen. While supporters of the act intended to disadvantage immigrant workers of all races, they were particularly concerned with inhibiting black employment. Supporters of Davis-Bacon were also full of anti-capitalist rhetoric. They stated that it would force the contractor who heretofore has used cheap labor, imported labor, to submit bids based upon the prevailing wage scale to those employed. It compels the unfair competitor to enter into the field of fair competition. The rhetoric of fairness dominates much of the contemporary debate over the Davis-Bacon Act as well. Now, just so that you know, 2 important modifications have recently been made in the way that the Davis-Bacon Act is enforced. In 1982, the Department of Labor altered the basis for determining the prevailing wage, deciding to equate the union wage with the prevailing wage only in places where the construction industry was 50% unionized. This change, however, had little effect on minority-owned firms' ability to secure contracts because union membership tends to be much higher in urban areas where large minority populations reside. The Department of Labor also attempted to alter its regulations to allow contractors to hire a limited number of unskilled helpers to work on Davis-Bacon projects for less than the prevailing wage. This change, which was to go into effect on February 4, 1991, would help to diminish some of the discriminatory effects of the act. But Congress, to this day, has prevented the department from enforcing it. Moreover, labor unions are now pressuring Congress and the various presidential administrations to repeal the changes. Similarly, President Bush suspended the act in South Florida, coastal Louisiana, and Hawaii in 1992 following Hurricane Andrew and Hurricane Inaki. But President Clinton, our buddy, Slick Willie, reversed course upon entering office and removed the exemptions. Now, just so that you know, Senator Hank Brown, a Republican out of Colorado, sponsored legislation to repeal the Davis-Bacon Act. A similar bill was introduced in the House of Representatives by another Republican, Tom DeLay. Both proposals have attracted congressional co-sponsors, but not surprisingly have failed to obtain majority support. Now, just to be specific about the effects of the Davis-Bacon Act, it imposes tremendous economic and social costs at least $1 billion in each year. Industry compliance costs nearly $190 million per year, and repeal of the act would create an estimated 31,000 new construction jobs, most of which would go to members of minority groups, i.e. black people. Davis-Bacon's impact on the ability of minorities to find work in the construction industry has been particularly devastating. The Department of Labor's initial set of regulations did not recognize categories of unskilled workers except for union apprentices. As a result, contractors had to pay an unskilled worker who was not part of a union apprenticeship program as much as a skilled laborer, which almost completely excluded blacks from working on Davis-Bacon projects. This effectively foreclosed the only means by which unskilled blacks could learn the necessary skills to become skilled workers. So when they talk about us pulling ourselves up by the bootstraps, they in effect cut the damn bootstraps, so there's no way that we can pull ourselves up. As a result, while black and white unemployment rates were similar prior to the passage of Davis-Bacon, they began to diverge afterwards. This problem persists today. But just so that you think that this information is erroneous, if we look at the first quarter of 1992, black unemployment was 14.2%. And even though the overall nation rate was only 7.9%, there had to be a reason for that. The reason was the Davis-Bacon Act. Even today, we look at the unemployment rates, and the last time I checked, the overall national unemployment rate was approximately 4.9%. The black unemployment rate is approximately 9.2%. So not quite double, but damn close to it. The construction industry, as most of us know, is particularly suspect because of the pronounced lack of black workers within it. I drive around the country a lot, and most of the construction jobs I see, roads, highways, bridges, etc., you don't see a lot of minorities on those projects. That's because they are not members of the particular unions. Now, that particular policy is not as bad, I'll say, in certain states, and I'll say certain southern states, only because a lot of these contractors subcontract out. Now, what comes into play is, quote unquote, the supposed government set-asides, which come into direct opposition to the Davis-Bacon Act. Most federal projects are supposed to set aside at least 10 to 20% of its project to minority contractors, minority workers. Surprisingly, most of these projects get around the fact that they need to hire minority workers by classifying women as minorities. So you'll get a contracting firm owned by a white male, and in order for him to get around the 10 to 20%, requirement of minority participation, he will turn around and have his wife open up a quote-unquote front business, a front contracting business, and funnel to her 10 to 20% of the contract. Now, since she is a minority by definition, that 20% rule just went out the window. The Davis-Bacon bill has never been repealed. Now, certain states have gone about repealing the requirements within their own states. The last one that I heard about was in West Virginia, where they actually did create a state law that negates this particular bill. And the federal government, I guess in its wisdom, haven't sued them or gone after them regarding this. It's kind of the same thing that you see with marijuana in the various states out west. Although marijuana is considered illegal by the federal government, especially for recreational use, various states have passed laws that have legalized it, and the federal government has chosen not to go after them. But my whole point on this is that the factors that have been created by the Davis-Bacon Act basically have prevented rural and inner city laborers and contractors from working on projects in their own communities, especially if they are minority communities. Now, just so that you know, there have been a lot of protests. I'm not talking about marching in the street. I'm talking about people that have become aware of this particular act and have written their Congress people in an effort for them to get rid of this particular act. But as usual, Congress has chosen to ignore the wishes of their constituencies. So the next time someone says to you that black people are lazy and need to pull themselves up by their bootstraps, you can point to the Davis-Bacon Act and tell them that it's the federal government that is the one that is preventing black people who want to work, who work hard, and all they want to do is get ahead. It's the federal government that's preventing minorities from pulling ourselves up by our bootstraps. Now, this particular act is currently undergoing a constitutional challenge. The challenge states that this particular law is racially discriminatory since it was passed to discriminate against blacks and immigrants, and as a result violates the equal protection guarantee of the Fifth Amendment. The courts need only to look to the legislative and administrative history of the law to determine that racial discrimination was among its purposes. The courts could also void the Davis-Bacon Act for impinging on the rights of individuals to pursue employment opportunities, thereby violating the Fifth Amendment's Due Process Clause. The Institute for Justice has brought together a unique coalition of plaintiffs to challenge the law. Complainants range from individual minority contractors who have either lost opportunities to successfully acquire government contracts or who have gone out of business altogether because the application of Davis-Bacon to resident management corporations who, because of the law, have become unsuccessful in their attempts to involve public housing residents in rebuilding projects at their own developments. This law was born of racial animus, and the Davis-Bacon Act has undermined the opportunity of economic outsiders to find employment in the construction industry for more than 6 decades. Given the influence of organized labor over Congress and the extent to which the previous administration's support of NAFTA alienated this key constituency, it's highly unlikely that either branch will risk further undermining union support by pursuing reform or repeal of the Davis-Bacon Act. Thus, the only avenue that we have in order to try to do something about this particular law is through the judiciary. The Supreme Court could do something about this, but chances are slim to none that that's going to happen. And given the fact that another conservative judge is likely to be placed on the Supreme Court, any attempt to do something about this particular law will be and is dead on arrival.